So part one is all the issues that come up during the course of the employment, and then Owen is going to deal with termination of employment and unlawful termination. And so I'm dealing with payment of wages, terms, conditions. We'll go through some case studies because I think it's the most practical thing to do. This, unfortunately, I'm not sure if it came out in your slides, but it's just a short synopsis of all the different pieces of legislation. Employment law is massive, as you know. But you'll see kind of the same topics tend to come up over and over. So they're not all crossed out. It's just the table is not in the correct format. So if you can understand anyone in employment, you don't need any minimum terms of service for most of the employment pieces of legislation to apply. And then 1 year services for unfair dismissals, which Owen will deal with, and redundancy payments as well. And I also put in the national minimum wage there, $9.55 an hour in 2018, and that's going to rise in 2019 to $9.80. Down at the bottom is 2P in bold, and the first two case studies are going to cover 2P. Now, 2P is massive, so this is a 20-minute talk. It's the exact same length of time as a consultation, so we're not going to delve into it in any huge detail. So the reason we were asked to speak is a lot of people are asking about the employment law, and particularly in relation to the consultations, just some really, really practical tips. It is a 20-minute consultation. Everyone is going to be totally consumed with any breakdown in their employment relationship. It's a sense of identity to a lot of people, and they're coming to the centres and they're very distressed. Some will come in with no documentation, some will come in with a suitcase, and there is a kind of a knack or a skill that you just have to calm them down and say, look, when did you start? When did you finish? What's your role? What's your salary? And now what's the problem? And a very good tip that I find is, I actually say to people when they come in, look, we don't give, the name might be a bit of a misnomer, we don't give free legal advice per se, because in 20 minutes you just don't have time to absorb all of this information and spit out a perfectly cogent legal answer. It just doesn't happen. So you refer them, or you say, well, this piece of legislation covers that, or you'll need to go speak to a solicitor. So, very important, check the contract of employment. And a lot of times people don't come with the contract of employment, so you're advising generally, which is helpful, but obviously the contract itself will always be the most important documentation. So the first question is a case study, and we're saying I'm working on a casual, part-time basis. Casual is a very loaded word. For a professional firm in Dublin while studying for my medicine degrees for the past 6 years. In that time I have worked a variety of roles such as secretarial, support staff, PA, marketing, etc. The firm has just been bought by another firm, and the casual part-time staff are being laid off with no redundancy. Am I entitled to redundancy? And we're going to have audience participation here, so hands up, yes to redundancy. A bit more oomph. Okay, so we have 4 or 5. Who says no? 4 or 5. Okay. Who has skipped ahead and looked at the answer already? Okay, we have a few more of those. The answer is no. And the reason I put this in is because this actually came up for me in an employment centre, and it stumped me. I said, well, and the reason it's stumping, and it's the bottom section there, section 7. So continuous employment is, as you'd expect, continuous employment. It's section 3 of the Redundancy Act. And the prerequisite for redundancy to apply is 2 years service, 102 weeks, and we're missing a bit there, but is you have to be a contributor for the purposes of social welfare acts. But section 3 sets out what is part-time, what is a break in employment. And that says if there's a 6-week period, which it's short time or layoff, and it says if there is a break that is longer than 6 weeks, that's a layoff and it breaks the period of service. Now that's very general, I'm not going to say that is it in all cases. But she was able to go back in this particular instance because she'd been there for so long, 6 years, and it was a very large firm in Dublin, very reputable firm that had been bought out by another firm. And she was able to say, well, in the last 2 years I haven't had 6 weeks where I haven't been working, so section 3 should apply. And the lawyers presumably had a look at it and said, well, there's a question here. So the answer is no, but actually in those circumstances she was able to go back with a cogent argument, and she did get the redundancy in the end. So I'm just pointing out, it's a good case study to show that the legislation is dense. So every time you're going back to source, you're saying, what is an employee, what is the contract? And each particular piece of legislation might carry a different definition. So this is the cautionary tale to say to you, look, it's 20 minutes. You're not going to be able to go into that level of detail in a 20-minute consultation. So the 2P, which I had to mention, I presume people are familiar with 2P, but they might be a little rusty on it. 2P is where there has been a change in the employer. And a very important thing in relation to 2P is a share sale, that the ownership name doesn't change and the shares are sold. So the ownership of the company is transferred, but it's not apparent. So the name stays the same. If the name changes, okay, 2P will most likely apply. But all of the preserved benefits in relation to the contract of employment are retained. So if you're there 20 years and your contract of employment says you get 2 weeks a year paid sick leave, and the new employer comes in, he has to preserve the same benefits that you were entitled to under the old contract of employment. It comes up a lot. It comes up a lot really in the environment that we're in at the minute. There's a lot of companies that are changing hands. And the biggest one, I think, typically that we see are hours of work where people are being asked to be more flexible, that might have been engaged in a particular arrangement, and relocation. And the other point I might say, in general, employees are entitled to have information 30 days prior to the transfer. That's almost an absolute. You can take a claim if you're only told 10 days prior. So we'll just move on. Next case study. I've been working for a firm which was bought by another firm. Prior to the transfer, I took on additional duties, and as a result, I got a salary increase and fixed expenses to make up for the additional overtime. After the transfer, my pay was reduced back to my contractual level, and all expenses have to be vouched in the future. My employer says they were on notice of the increased salary, but it was only temporary due to the increased duties, which were temporal, and my contract level is at the applicable, my salary level is at the applicable contractual rate. They're also refusing to give me any unvouched overtime which existed under my previous employer. What are my rights? So, hands up who says it's the previous contract of employment that applies, having regard to the temporal nature of the arrangement. Any votes? 3 votes. Anyone saying that it's not going to apply? No votes. 1 vote. Has anyone skipped ahead and looked at the answer? No votes. Okay, we might abandon that. So this is the facts of an actual case. This is Leeson and Company v. Robert Nagel. And this is an interesting one. We'll skip to the end. I'll tell you what happened anyway, because I know you want to know. The adjudicating labour court held the new employer was bound by the increased salary, being on notice of it. And that's really important, because the increased salary wasn't just the increased pay that was for the temporal arrangement for the additional duties, but also included what was put into pay, which was the overtime. Now that's really interesting, because Section 1 sets out, not the overtime, the expenses that were in for the overtime. So instead of getting an overtime, they just banged it in as an expense. Section 1 expressly sets out that expenses are not wages, they're not emoluments. Fees, bonuses, commission are wages, but expenses are not. And the reason, and this is a very recent case, it came out at the start of this year. I might say actually all of these case studies are quite recent. It kind of just goes to show how strong 2P is and how protected it is. And if you don't do your due diligence when you're advising a firm that's coming in, tough. I mean, bluntly, it's that strict. So that's a cautionary tale. The next study is, I've been employed as a receptionist. My contract of employment describes me as a general operative. I received a new contract of employment which describes me as a cleaner. The statement of my terms and conditions of employment did not include a reference to my hours of work, merely a reference to 48 hours work, which could have been rostered between Monday and Sunday. Am I entitled to compensation? Votes? Yes? 2? No? 2? Okay. I'm sorry for foisting that on you. The answer is no, in this case. And this case and the next case are linked. And this is the facts. It's Rapier Contract Service versus Anna Predut. I apologise if I haven't pronounced that correctly. But this sets out the Section 3 of the Terms of Employment Information Act. It says all of the things that you're supposed to be given within 2 months of the commencement of your employment. And the section itself is very prescriptive. It's very detailed. So Who's the employer, who's the employee, nature of the work, place of work, date of commencement, pay, hours of work, sick pay, paid leave, incapacity and sick pay, which a lot of the times isn't given, pension and benefits and periods of notice. That statement should be kept on the file for a year after employment. Now the adjudicator applied what I think really is a common sense approach. Okay, there's a misdescription in the contract, but both parties knew what your job was. You'd been working there for a period of time. It was the first contract and the second contract. It wasn't even the first contract was the problem, it was a second contract. And on appeal, the Labour Court agreed. Now, the reason I found this case interesting, when you put it next to the facts of the next one, is I'm employed for 6 months. I wasn't given a correct statement listing the particulars of the terms of my contract, in that it listed my employer as X Ireland Limited instead of X brackets Ireland Limited. It also didn't set out the terms and conditions as to the hours of work. I'd be notified in advance, and the statement provided that the leave year was to run from January to December instead of April to March, as set out in the Organisation of Work and Time Act. Now, if you think about the Organisation of Work and Time Act, that was done when the tax year was April to April. Now it's January to December. Most contracts of employment will run January to December and will not be consistent with the Organisation of Work and Time Act. That's just a historical quirk that we have. But the parenthesis around Ireland Limited, if we're to go on the facts of the last case where they've kind of applied, well, you know, it's not a totally separate company, you would think they would be consistent, but no. No recruitment v. Artris Glesma, the adjudication officer head the above was not material, was appealed to the Labour Court, and the complainant was awarded 1 week's wages as compensation. Now the and costs should have a question mark after it. Do you get costs in the Labour Court? You don't. You don't. So they get their 1 week's wages as compensation and a big legal bill for going to the adjudication and going to the Labour Court for their parenthesis. So yay, they won, but did they really? You know, these aren't cases that you want to be bringing, but it just goes to show, I suppose, the strictness of the statutory interpretation when it comes to being in breach of particular terms. Case study 5 is implied terms, and these are terms that are written into a contract of employment that don't exist into the contract of employment but are brought in by custom and practice in that particular employment. So I've been off sick for 1 month and work in the private sector. My contract of employment says that sick pay is at the discretion of my employer. I've been paid to date, but my employer has written to me to tell me I will not be paid in future for any sick time. I've been sending in medical certs to cover the time off. Am I entitled to paid sick pay for the remaining time I'm out? Now the contract says no. So if I was to ask you to take a vote, I would guess that we would have the same 4 no's that would have it, but generally no. And the reason I say generally no is that if you can find somebody in your organisation that has been treated in a particular way that is not consistent with the contract of employment, you have a good arguable case to say, well, that's an implied term in my contract. Now, we'll talk about that in a moment. So the contract of employment sets out the payment is discretionary. However, there can be applied term in the contract if they have an established practice over a long period of time. If a number of colleagues have been paid for 2 months for sick leave or longer durations, then the employee could argue there's an implied term that sick leave is paid for longer than time, regardless of contractual terms. Now, this is the interesting bit. The burden of proof is on the employee to show that such an implied term exists. And if you think about any organisation, if people are treated in a particular way that is quite favourable, that's not a legal issue. That often can be an issue where they just get on with their manager and they say, don't worry, we'll look after you for the 2 months that you're out, or you know. And then you also have to get your colleague to come and give evidence, or you know, this is the privity of contract question. It can exist, but unless you have fairly robust kind of evidence to bring in and a willing witness, which often isn't the case, I would say unless it's in the contract, you're going to have a hard time, and the burden of proof is against you. So the last one, I've taken my case to the WRC for redundancy. The employer did not turn up. The employer had 6 weeks to appeal the decision and did not do so. So in this set of circumstances, I've gone to the adjudication, I've won, I've gotten my award, fantastic. The period of time to appeal it has elapsed. However, they've now put in an appeal outside the time limit. It appears that they had moved premises and not gotten any of the correspondence, and I understand an application is going to be made to the High Court to allow the appeal to progress for exceptional circumstances. This seems unfair to me. Will the court allow them to appeal? It's the last vote of the day. Yes? No? No.
is fundamentally unfair. But
So we're going on breach of fair procedures?
I think so, yeah. I think that's where we're going to go with that. It's just, unfortunately, things tend to go in the
We're all lawyers, so if you're out of time, if you go up to An Bord Pleanála at 5:05 on the last day, will they be like...
People have done it, like, with books on it, so, you know, there's a reason.
It does happen, and it... Well, let's go back, actually. Hold on now, this is interesting. What was the other point? Who was the converse?
I was saying somebody wrote down here, this depends on the particular circumstance.
Oh, right. Your answer C, you've skipped ahead. It does depend on the particular circumstances. In this particular case, the appeal was allowed. And I think this is quite unusual, really. And it's so particular to the circumstances, because in this particular case, the respondent had to vacate their premises on foot of a court order. And personally, I think that's key. If they had voluntarily had to leave the premises, I don't think they would have gotten the same sort of leeway, but they had to vacate on foot of a court order in August 2016. And in January 2017, they got their paperwork in order, they changed their address in the CRO. They claimed to have not received the correspondence from the WRC and only became aware when the complainant wrote and said, "Where's my cheque?" So the court held that in those particular circumstances, the exceptional circumstances provided by Section 44.4 of the Workplace Relations Act applied. Now, that section is rarely triggered. Well, it's often argued, but rarely successfully. I'll put it that way. In my view, well, I mean, it's good law. The case is there. I'm not sure how many cases they're going to follow it, but I found that a really, really unusual case. And that's it. With no further ado, I'll hand you over to Owen.
So what I want to talk to you about is what we've kind of roughly classified as being the breakdown of employment relationships and termination of employment type cases. What I have done, and I'm not sure that it has come out really in the slides, I should say what I lack on photos I make up for, or try to make up for on OCD flowcharts. But basically the idea here is to give you a basic overview of the types of claims that might be available to an employee who comes into you. I'm conscious, as Siddhanta said himself, that you're talking about a 20-minute consultation. Employment law is dense and it's nuanced. You're not going to be able to give a definitive answer at the end of that. But what you hopefully will be able to do is give some guidance as to where that employee should go, what their rights might be, and you might even be able to give a bit of a steer in terms of the merits of the case that they intend on bringing. So the first thing really that you need to check when you're dealing with an employee who has been terminated is firstly the length of service. That's the first thing, because if they have over a year's service, they have an immediate option of bringing an unfair dismissals claim. The Unfair Dismissals Act doesn't apply to most employees, the vast majority of employees who have under a year's service. There are certain exceptions where an employee has been, let's say, dismissed for pregnancy or dismissed because they made a protected disclosure or in connection with trade union membership. Those types of cases fall into the absolute minority of cases that might be coming before you in a FLAC centre. So as a general rule, that's the first thing you need to look at. If the employee has over a year's service, the question then is whether or not it might be the type of claim where they would be successful in arguing that the dismissal was unfair. And as some of you may well be aware, and for those of you who are aware and well versed on this, I apologise, but effectively the three headings that are available to an employer, the three main headings I should say, available to an employer who is looking to dismiss an employee is firstly on the ground of competence or capability. Secondly, they can dismiss fairly on the grounds of conduct or misconduct. And thirdly, on the grounds of redundancy. So when you're looking at a misconduct redundancy or a competence-related dismissal, the key thing in virtually all cases is what procedures were followed. Because the vast majority of cases where there's a finding in favour of an employee and an award of compensation are cases where the employer has not followed their procedures. So if you're in a space where the employee has over a year and they've been dismissed for one of those reasons or other, the next thing is to consider whether or not there has been a breach of the employer's procedures. And by that I mean there would usually be an employment handbook if it's a large enough company. There might be policies that they have in place around dismissals. The contract of employment will, if there is a written contract of employment, likely set out some of the terms on which an employee might be terminated. And finally, there's a general right under the Constitution, an implied right that is in every employment contract, and that is a right to fair procedures. And they will apply to virtually all cases, though the types of procedures that need to be applied will differ depending on the type of dismissal. If it's a dismissal in relation to misconduct, there's quite a suite of fair procedures that would be expected to be applied by an employer. For those employees that have under a year's service, they're in a slightly more precarious situation in terms of finding the basis for a claim. As I say, there is a small number of dismissals that might fall into the exceptions under the Unfair Dismissals Act, where an employee can bring a claim even though they have under a year. But the majority of employees who have a claim and are under a year's service will be bringing that claim under the Employment Equality Acts. The major distinction in terms, at a practical level, in terms of the proofs and the evidence that you have to establish when you're bringing an employment case, is really you have to say that that dismissal is connected to one of the 9 discriminatory grounds. Okay, so no matter how unfair the dismissal might be, unless you can establish that link between the dismissal and one of those 9 discriminatory grounds, you do not have a case under the Employment Equality Acts. So the flowchart kind of gives you a number of questions that you can ask employees and hopefully diverts you towards the types of claims that they might be able to bring. As I say though, in a 20-minute consultation, you're not going to be able to be definitive about it. The second area that I just wanted to give you an overview on is what I'm broadly going to call unfair treatment in the workplace. Okay, now there are various different types of claims that employees can bring when they've been treated unfairly. These types of claims are generally referred to bullying and harassment. Bullying is a bit of a misnomer. It's not a cause of action in itself. Bullying is, when it's accompanied by other elements, might give rise to a claim. So if somebody has been treated badly, and there's the Health and Safety Authority's definition of bullying is put up there. There are a couple of options that might be open to them. The first is that if they have been injured as a result of that mistreatment, so if they have a recognised psychiatric condition that has been caused as a result of that bullying treatment, then they may be able to bring a personal injuries claim in the civil courts. If they leave their employment as a result of the bullying, they may be able to make out the case that they were effectively given no alternative but to leave, and that they were therefore constructively dismissed. That's a subcategory of an unfair dismissal claim that they may be able to bring. Some employees might be able to bring a claim for breach of contract if the bullying was, if you like, amounted to a breach of the terms of their employment. Let's say their employer was cutting their wages unilaterally without any kind of agreement. There might be an opening there to bring a breach of contract claim. Harassment, even though it's used generally in language to describe that kind of unfair treatment, in legal terms, harassment is unfair treatment that is connected, again, to one of the 9 discriminatory grounds. So if you're bringing a harassment claim under the Employment Equality Acts, the reality is that you have to establish that link between the bad treatment and one of the discriminatory grounds, either race, religion, age, gender, and so on and so forth. The third category of type of claim that might come up when somebody's been treated badly is, again, broadly I'm referring to as penalisation or victimisation. And they're specific provisions that have been stitched in to different pieces of employment legislation to protect employees from retaliation by their employers for them invoking their rights under those pieces of legislation. So, for example, if you are, and I've listed different pieces of legislation there, the Organisation of Working Time Act, if you feel that you aren't being given your breaks or your rest periods and you confront your boss about it, or you make a formal complaint about it, or you bring a claim about it, or maybe you're a witness to somebody else's claim about mistreatment under that act, then you are provided with protection. You should not be treated or penalised by your employer by reason of you raising that concern. So that's a very general overview of the different types of mistreatment. The next thing I wanted to just give you an overview on before I got into just a few of the case studies is the concept of fair procedures. Now there's an academic kind of an overview of what we're talking about when we're dealing with fair procedures, but if you go specifically, if we just focus on the issue of conduct or misconduct when an employee has been accused of doing something wrong or behaving inappropriately, there are certain fundamentals that an employee should expect when they are accused of doing something wrong. They should be given the evidence that would be relied upon by their employer against them. They should have sight of that. They should be given the opportunity to defend their position in the context of a formal process. They should be given the opportunity of rebutting the evidence, and they should be, in many cases, given the opportunity actually to confront their accusers or to cross-examine. And that's something that was the subject of recent case law, where the High Court found, and I have the cases there, where the High Court did uphold an employee's right to cross-examine. And we're doing there on time, Eilish and Constance. So, case studies. The first one, I'm a Colombian national. I've been working for a retail company for 7 months. I'm the only non-European staff member in the company, and I felt for some time that I've been treated less favourably than others in my terms of employment. Last Monday when I attended work, my boss pulled me aside and said that he no longer has a requirement for me in the business. He paid me for that day and sent me home. I've learned from one of my work colleagues that someone else took over my job 2 days later. So what kind of a scenario or claim might that person bring? Well, that person has less than a year's service. So the immediate assumption is that they probably aren't entitled to bring a case under the Unfair Dismissals Act. Given your nationality and your view that you've been treated less favourably than in the course of your employment, there's a possibility that your dismissal was effected for discriminatory reasons. So this person will be advised to consider the possibility of bringing a claim under the Employment Equality Acts for discriminatory dismissal and possibly discrimination if they felt, because they had mentioned that they were treated badly during the course of their employment. So that claim will go to the Workplace Relations Commission, and it would need to be brought within 6 months, in the case of discriminatory dismissal, 6 months from the date of the dismissal. Okay, there is the possibility for an extension of time, though it can be often difficult to convince an adjudicator to give you that extension of time for an additional 6 months. In relation to the discrimination itself, if that employee felt that she was being treated badly at work, it's 6 months from the date of the last act of discrimination. So it would be expected in that case that the employee would lodge submissions or file a statement setting out the details of their claim, and that they would be able to point to somebody else in that workplace who was not treated in the way that they're saying. So somebody who hadn't been dismissed or somebody who hadn't been discriminated against on one of those 9 grounds under the Employment Equality Acts. If they're successful in the claim, the majority of cases result in a finding that the employee should be awarded some sum of compensation, and there's a maximum of 2 years' salary can be given in those types of cases. So the next case study is, I worked as a mechanic in a small family-owned garage. My employer pays me €480 per week, 200 of which is paid to me in cash. About 5 months ago, my boss confronted me to say that a customer had complained that their car had been badly scratched while I was in the garage. My boss said that as I was the one who serviced it, I was obviously the one who scratched it. He said that he had received complaints like that before and that he had no choice but to let me go. I had no idea what complaints he was talking about. He told me he would pay me a week's wages and asked me to leave the garage floor. So what kind of claim might that person be able to bring? Well, again, assuming they have over a year's service, the obvious option available to them is an unfair dismissal claim. There's a kind of a preliminary point, and this comes up in employment law quite a bit when somebody's paid in cash. There can be an issue around the legality of the contract itself. Now, that's a common law principle, okay, that applies to all contracts. But if the contract was entered into for an illegal purpose or was performed illegally, then it might actually be that the contract itself is illegal and a claim can't be brought. There was a certain situation, whenever it was, back in the early 90s, late 80s, that employers were actually getting off the hook in unfair dismissal claims because they were saying, oh no, it was an illegal contract, nobody can sue on foot of it because this person was paid in cash. So there was a 1993 amendment to the Unfair Dismissals Act which specifically said that if somebody had been paid in accordance with an arrangement that, if you like, didn't follow the rules relating to revenue or social welfare rules, that won't preclude an employee from bringing a claim under the Unfair Dismissals Act. So the dismissal would appear to be one relating to perceived misconduct or incompetence. In either case, your employer would be required to take certain steps, including following internal procedures of the company if they exist, and follow basic fair procedures. It would appear that there was no proper inquiry or investigation into the issues alleged. In particular, you were not properly informed of the evidence and complaint against you. You did not have an adequate opportunity to respond. You were not given an opportunity to challenge the account of your accuser. So on the face of it, that would appear to be quite a good unfair dismissal claim that person will be able to bring. And I've set out the procedures that the general kind of an overview of the procedures that would need to be followed in terms of bringing an unfair dismissal claim, which I won't dwell on now. Okay, the next one. I've worked in an accountancy firm for 7 years. 2 years ago, I began reporting to a new manager and very quickly encountered an intolerable working environment. I've been subjected to bullying behaviour, unwarranted criticism and isolation on a daily basis. I've reached the end of my tether and can't take it anymore. I'm overcome with anxiety every morning on my way to work. I've tried to raise concerns in an informal way with other colleagues, but I'm afraid to speak up or make a formal internal complaint, as I feel this will only result in retribution by my manager. So the type of situation that person finds them in, going back to what I was saying about bullying, is that they've been treated badly, but in order to be able to bring a claim, they have to have an additional element that would entitle them to bring some form of a claim. The first was the bad treatment related to one of the 9 discriminatory grounds? So in this case, there isn't any real evidence to suggest that this person was being discriminated against on the basis of one of the 9 discriminatory grounds. So it doesn't appear as though there's a harassment claim. The second is, did the person suffer medically? So we have them saying that they're overcome with anxiety. That might be an indication that actually they have a medical condition. So if they've been diagnosed or would likely be diagnosed with a medical condition if they went to the doctor, there might be a possibility that they could bring a personal injuries action for the way in which they've been treated. There are various hurdles, proofs that you have to overcome in a personal injuries action that I'm not going to dwell on, foreseeability, causation and things like that. They're notoriously difficult cases to bring home, but it is potentially an option that's open to them. And the third option is constructive dismissal. So the employee hasn't yet left their employer, but they may decide to do that. If they do that, they may have an opportunity to bring a constructive dismissal case. One thing that, if there's one rule of thumb or something that needs to be flagged in any case relating to constructive dismissal, is that it's almost universally expected that if somebody is going to walk out of their work saying that they could not possibly have been expected to stay on in employment, it would be expected by the WRC and the Labour Court that they would exhaust the internal procedures. So if there's an issue, you bring a grievance or you make a formal complaint. Provide your employer with an opportunity to actually fix the problem before you leave. And then the last one that I wanted to touch on is I've been working as a waiter in a particular establishment for 6 years. Last week my boss invited me into his office and told me that a fellow employee saw me taking money out of the tip jar in the restaurant. All tips left by customers in this jar are pooled each evening and divided equally amongst all staff. My boss told me that he reviewed the CCTV footage and that shows me taking money from the jar 3 times in one evening. I was shocked and asked to see the CCTV. He told me, stop playing games, admit what you've done. I did not respond. He told me that I was being dismissed with immediate effect. I accept that I took money from the tip jar on rare occasions, mainly to buy cigarettes on my break. I know it was wrong, but I have been treated unfairly. I don't think that he has followed fair procedures and he has refused to show me CCTV. So this is actually quite a typical kind of a scenario where somebody is coming and they feel that they have been wronged. They've been told by somebody that my rights have been breached. I know I have a right to fair procedures, or there should have been an investigation, but that appears not to have been followed here. The question is, does that person have a claim? Well, they might well have a claim under the Unfair Dismissals Act. They might well be successful in convincing an adjudicator that they hadn't that the employer hadn't followed fair procedures in that process. But you have to think ahead a little bit. The reality is if that case goes to hearing, the employer is going to rock up with all of the evidence, if it's there, and the CCTV footage and whatever else. And the employee is effectively admitted to you that they had done this. So even if they do get a finding of unfair dismissal in their favour, it might just be a technical finding where the adjudicator is saying, yes, you didn't have your fair procedures afforded to you, but I believe that actually you contributed towards your own dismissal. And there's a specific provision under the Unfair Dismissals Act, which is section 7.2b of the 1977 Act, which permits an adjudicator, when deciding on the level of compensation to give in any claim, to look at and examine the extent to which the financial loss was attributable to an act, omission or conduct by or on behalf of an employee. And so that effectively gives them carte blanche to say, okay, you're right, procedures were wrong, but actually I think you caused this yourself. And fundamentally, if they are sufficiently convinced at a hearing that an employee had been taking tips from a tip jar, the reality is that they're not going to get a huge amount of sympathy. And on that, I didn't mention the case, but there was quite a well-known case at the time that circulated, certainly in employment law circles. You may or may not have heard of it, and it was a case actually against a very well-known retailer and grocery shop. And there was somebody who had been fired, who was working at a deli counter, and who had one of the main reasons for the dismissal was because she had eaten some chicken goujons or chicken nuggets. She was caught on CCTV doing it, and most people's view at the time who knew employment law would have thought, okay, well, there weren't procedures there, and even assuming she had done this, which she accepted she had done, that it was massively disproportionate to just sack her for doing that. But the case went through the employment fora. She was successful. She got a relatively modest amount of money. It was appealed as appeals went up at the time to the Circuit Court, and the Circuit Court judge actually found that her conduct amounted to a breach of the implied term in every contract, that there would be trust and confidence between an employee and employer. So the judge found in that case that through her actions, even if it was didn't have a huge financial value, that actually the dismissal was justified. Okay, so I'll leave it there with that. Thank you very much.